basis without warranty or condition of any kind, either express or implied, to the maximum extent permitted by the applicable law. The Roblox entitles this claim to all warranties of any kind, whether express or implied, relating to the service and all materials and content available through the service, including A, any implied warranty of any merchant ability. Okay, in this, for a particular purpose, title, quiet enjoyment, or non-infringement. And B, any warranty arising out of the course of dealing, usage, or trade. The Roblox entitles do not warrant that the service of or any of the service or any materials or content offered through the service will be uninterrupted, secure, or free of any errors, viruses, or other harmful components, and do not warrant that any of those issues will be corrected. No advice or information, whether oral or written, obtained by you, by the service, or any materials that are content available through the service to create any warranty regarding of any of the Roblox entitles or the Roblox that is not expressly stated in these terms, you assume all risk or a damage that may result from your use or access to the service. You're dealing with any other service user, and any materials or content available through the service. You understand and agree that you use the service and use access, download, or otherwise obtain materials or content through the service and any sites or servers. You, at your own discretion and risk, that you are solely responsible for any damage to your property, including computer system or mobile device used in connection with the service, or the loss of data that results from the use of the service or the download or use of the material or content. These limitations apply to the maximum extent permitted by the applicable law. To the maximum extent permitted by the applicable law, in no event will the Roblox entitles to be liable for you indirect, incidental, special, consequential, or punitive damages, including damages for your loss of profits or goodwill or any other intangible loss arising out of or relating to your access to or use of or inability to access or use the service or any materials or content on the service, whether based on warranty, contract, tort, including negligence, statute, or any legal theory, and whether or not any Roblox entity or has been informed of the possibility of damage. To the maximum extent permitted by the law, you agree that the great liability of Roblox entitles you for all claims arising out of or relating to the use of or inability to use any portion of the service or otherwise under these terms, whether in contract, tort, or otherwise, is limited to $100. Each provision of these terms provides a limitation of liability, disclaimer of warranties, or exclusion of damages to allocate the risk under these terms between the parties. This allocation is essential to the element of basis of the bargain between parties. The limitation in the Section 10 will apply even if any remedy fails of its essential purpose. You and we agree that each may bring claims against the other only in your or our individual capacity and not a plaintiff or class member in perpetrated classes representative proceeding. You and we agree as follows. A. Neither you nor we seek to have a dispute heard as a class action, private attorney general action, or any other proceeding which either party acts or purposes to act in a representative capacity. And B. No arbitration or proceeding can be combined with another without the prior written consent of all parties of the arbitration or proceeding. And C. If the class action waiver of any part in this Section 11 is to be found illegal or unenforceable as to all or some parts of a dispute, those parts will be severed and proceed in a court law, with the remaining parts proceeding arbitration. Governing law. These terms are governed by the laws of the state of California without regard or conflict of law principles. If a lawsuit court proceeding is permitted under these terms, you and we agree to submit to the personal and exclusive jurisdiction of the state courts and federal courts located within the Northern District of California for the purpose of litigating any dispute. Agreement to the arbitrate. You and we agree to arbitrate all the disputes except the exceptions specifically set out in the next subsection. Between you and us or our arbitrates except disputes related to our intellectual property rights. Disputes mean any dispute, action, controversy, or claim arising out of or relating to any aspect of these terms, whether based in contact toward statute, fraud, misrepresentation, or any legal or equitable basis, and regardless of whether a claim arises or after the termination of these terms, you and we will empower the arbitrator with the exclusive authority to resolve any dispute, including without limitation of any of these terms is void or voidable. We both agree that nothing in these terms will be deemed to waive, preclude, or otherwise limit either of us to A. Bring an individual action in small claims court. B. Pursue a enforcement action through the capital, federal, state, or local agency if the action is available. Seek injunctive relief in the court of law, or D. To file a suit in a court of the law to address an intellectual property infringement claim or compel to or upload any arbitration decision hereunder. In such cases, neither nor we shall need to follow the informational negotiations procedure and timeline set out in the subsection. To help you and us to get a resolution and control costs for you regarding any dispute, you and we agree to first attempt informally discuss and try to negotiate a resolution to any dispute for at least 60 days when from notice the dispute is sent. The informal negotiations will commence upon written notice from you to us or us to you. We will send our notice registered email address and billing address to provided to us. You will send your notice to Roblox Corporation, Legal Department, 60 3rd Avenue, number 115, Sacramento, California 94401. After 60 days, or we may commence arbitration if the dispute cannot be resolved within that time period. And if you or we desire continuing the dispute and the party desiring to continue the dispute shall commence arbitration. If you and we do not resolve in the dispute by informal negotiation, the dispute shall be settled by binding arbitration before a neutral arbitrator whose decision will be final except for a limited right of appeal under the U.S. Federal Arbitration Act. You agree that you are giving up right to litigate a dispute in the court before a judge or jury and giving up your right to a class action. Arbitration will be administered by the American Arbitration Association under its commercial arbitration rules and supplementary procedures for consumer disputes. You can find more information at www.adr.org or by calling 800-778-7879. An arbitration be conducted in person through the submission of documents by phone or online. The arbitrator may award damages to you individually as court could, including declaratory or injunctive relief, but any extent required to satisfy your individual claim. Fees and location. If you commence arbitration in accordance with these terms, we will reimburse you with your payment of the filing fee unless your claim is more than $10,000, in which case the payment of any fees will be decided by the AAA rules. Any arbitration hearing that will take place at a location agreed upon in San Mateo County, California. But if the claim is $10,000 or less, you may choose whether arbitration will be conducted